Yes, that's great. So would you like to reserve 5 minutes for rebuttal?
I would, Your Honor, thank you.
You can start whenever you're ready.
All right, thank you. May it please the court. In this particular case, the lower court failed to follow the law as was its duty. This was a simple breach of contract case involving the interpretation of an insurance policy. The court did not, so it had a responsibility to resolve any, it had the requirement to stay within the 8 corners of the complaint, and then also to interpret the insurance policy with all ambiguities in favor of the insureds. It did not do that. And how do we know that? We know that from the trial court's very own words. The trial court actually, in his recitation of facts, he wrote that in addition to being the sole manager and member of the LLC, Steinberg works as a hands-on employee as well as an owner and operator of Botanical. That's nowhere in the record, Your Honor, and there was no testimony on that at trial. The trial court also...
So let me just stop you there. So Steinberg was not present at the scene of the incident?
Steinberg was present at the scene of the incident, yes.
And he is the sole operator of Botanical, I think it's called. Is that right?
Yes, Your Honor.
That's an LLC, and he's the sole member of the LLC. Is that right?
That's correct.
And he was at the scene when this tragic incident occurred.
That's correct.
So that part of it would be true. He was on the scene, and therefore his actions on the scene can be attributable to him alone, right?
To him alone.
Right.
Correct.
And he also implicates the LLC, doesn't he?
We say no, at least for purposes of this, because of the separation of insurance provision.
Well, so even if we accept what I think you're going, which is that there's no evidence or allegations to support that, that Rodriguez, the deceased, is that his name?
Yes.
No,
Rodriguez.
yes, Rodriguez.
Rodriguez was a worker of Steinberg or was a employee of a contractor of Steinberg. He was a contractor of an insured, and it says any insured, so the exclusion applies, right?
So our position is when you say the exclusion applies, you have to then look to the separation of insurance provision.
Well, but the separation of insurance position might work if it said, you know, bodily injury to any type of employee or worker of the insured, which would be Steinberg in this instance, which is, he's trying to get coverage. But instead it says any insured. So in other words, like, yeah, okay, you substitute Steinberg in there for the insured. If it's at the insured, we're talking about whether the exclusion applies in the instance of Steinberg trying to get coverage, then the separation of insurance might work in your favor. But here it says bodily injury to any type of employee or worker of any insured. So even if we're talking about Steinberg, and even if you don't substitute Steinberg for any insured, that means all the insured, that means all. So any one of the insureds, if this employee who was injured, and, you know, for which, you know, the insured Steinberg could become liable, it's excluded because that guy was a worker of one of the insureds.
Well, Your Honor, even the appellees say that the separation of insurance provision applies, and they then try to distinguish it with ILO. So I can talk about that. They do concede that the separation of insurance provision does apply. And then they try to rely on the ILO case, which involved a completely different type of policy. It was a watercraft policy. And in that particular case, the court was referencing Taylor, and they argued that they were distinguishable because they involved different policy language than that. Well, I'm distinguishing it. That different policy language was different than what was before this court. And then the court concluded in that case that with the observation that it's unlikely that parties to a policy would include clauses in a policy allowing voting claims under narrow circumstances, but intend those exclusions to apply to one member while having no impact on other family members who are also insureds under the policy.
It's a rough analogy, but what doesn't it obtain? Because, you're saying, well, this exclusion applies to, a botanical, but not to Steinberg. Even though the exclusion says, if you are a worker of any insured and you get injured, that's not covered. Or if you are an employee of a contractor of any insured, that's not covered.
We're saying that the court couldn't decide that based on the record before it.
Well, I thought I was complying with three corners. I was looking at the allegations and I'm looking at the insurance document. And what are the allegations that say that it's important that Rodriguez is not the employee of one of the insureds?
Well, we're not here. That is the point, Your Honor. There's no allegation in the fourth amended complaint that says that.
Well, wasn't he I'm sorry, it's a confusing fact pattern, but somebody was a contractor for an insured, right? That's horticulture, right? Am I getting mixed up? Who's the insured? Botanical?
The insurance, Rodriguez?
Yeah, so horticulture, no, the decedent's Rodriguez. The horticulture is the contractor that was subbed out by Botanical, is that right? Am I wrong?
No, that's incorrect.
Okay, then tell me what's correct.
Okay, so the, Mr. Rodriguez was hired directly by, Mr. Steinberg.
So he didn't work for horticultural? Rodriguez?
He did, but not at this time,
Okay.
okay?
So because he was on the scene on behalf of horticultural, he was being directed in his work by Steinberg.
He was at the scene on Steinberg's behalf. Horticultural wasn't involved in this day at all.
So he was not performing work pursuant to his employment by horticulture, which is a contractor of the insured Botanical.
Correct, he was not working for them at all.
There's no allegations to that effect.
Not to my knowledge, I'm continuing to look, but, okay, but I know that to be
Is it
accurate.
the height thing or something like that?
Excuse me?
Is that because of the height limit or?
I don't know exactly why, Mr.,
Seems incumbent on you to explain why, if he was an employee of horticulture, he wasn't there on that day as an employee of horticulture, which is a contractor of Botanical, which is an insured, which seems to come under any insured in the exclusionary language.
okay, so
Does that make sense?
there's the disconnect there.
Okay, sorry.
All right, so excuse me. The disconnect is that you have to take horticulture out of the picture at all, okay? They weren't there that day. And they weren't there that day. So the only people who were there that day were Mr. Steinberg and Mr. Rodriguez.
Mr. Steinberg, who is the principal of Botanical Solutions,
Correct.
which hired Horticopia,
No.
contracted with Horticopia, right?
Right, but not for this scenario.
Okay, well, opposing counsel will or won't point to allegations that support that Rodriguez was working for Horticopia at the time of this death. Right. I'm sorry, maybe my colleague could disabuse me of whatever my confusion is, sorry, but, or you could. Sorry.
I think it's paragraph 14 of the operative complaint where it says on September 24th, Rodriguez, while working within the scope of his employment with Horticopia, is that not an operative allegation in the complaint? And I guess maybe that is some of the confusion we're having.
Oh, now I see. So I can't explain why the complaint says that, but there was no evidence of that at trial.
We're talking about the duty to defend, right?
Right, no, I know, but I'm just,
We just talked about the 8 corners.
like, we are talking about the 8 corners. Okay, I understand what you're saying, Your Honor. Thank you.
You have another argument, which is that even if you concede that there's allegations to support that Mr. Rodriguez was an employee of a contractor for the insured Botanical, that for purposes of exclusion for Mr. Steinberg, he had to be working directly with Mr. Steinberg.
That's correct, Your Honor.
My counter argument had been that separation of insureds doesn't apply here because it says any insured.
So if we look to the case law, they address that issue directly. For instance, in Premier, where they say, the court acknowledged that its interpretation of the exclusionary clause rendered the term any insured superfluous, but held that such interpretation would be preferable to one which would render the entire severability clause meaningless. So that's in Premier on page, I think it's 1056, Your Honor. And then I can go through each one of the separation of insured cases and point out that same sort of language. If you look at Alamo Cruz, for instance, and Premier Justice 632 Southern 2nd, 1054, Florida 5th DCA, 1994. Alamo Cruz is 369 F sub 3rd, 1279, 1277.
Okay, we've got, they're in the briefs, right?
Okay, thank you, Your Honor. Was trying to be helpful.
No, that is.
Okay. So again, in that case, they rely heavily on the Evanston case, But there, no, this is in Alamo Cruz.
Okay.
Okay, so they go on to say that the policy had an exclusionary provision that provided in part, this insurance does not apply to bodily injury to an employee of any insured arising out of and in the course of his employment by any insured for performing duties related to the conduct of any insured's business. And then it goes on to say the policy also had a separation of insured provisions stating that this insurance applies if each name insured were the only named insured. So
You're at your 15 minutes. You're in your rebuttal, but it's your time. You can use it any way you want.
I'll wait, Your Honor.
Okay.
Okay,
All
thank
right,
you.
you'll have 5 minutes when you come back.
Okay, thank you.
Please the court. I want to clarify one procedural item before we start. This was not a breach of contract action, it was a declaratory action. The carrier was the plaintiff in the lower proceeding, so Cypress sought a declaration of its rights. I don't know that it matters necessarily substantively, but I wanted to clarify that.
Well, and I understand your point, but what we're really here to talk about is what the insurance contract says and what it doesn't say. Is there coverage or isn't there coverage, right?
There is absolutely no coverage, Your Honor. The purpose of these clauses, as we know, is to exclude coverage for employment-related injuries. They're recognized and enforceable in Florida. The basis for that is really that the hazards associated and the risks associated with employment-related injuries are different than injuries to the
So
general
was
public.
Rodriguez an employee of Steinberg and Botanical, or was he a subcontractor?
Well, that question.
It doesn't matter.
I don't think it matters ultimately. I think that question goes to one of the issues here, which is why is this complaint pled the way that it was? Because the complaint has conflicting allegations. Some are conclusions of law, which I don't believe the court needs to consider because they're not conclusions of ultimate fact. We know that in the count against Mr. Steinberg, the complaint alleges that he was a direct employee. And we know that because starting at paragraph 39, and particularly with regard to the duties that the plaintiff in the underlying case alleged that Mr. Steinberg personally owed, those included things like provide a safe work environment, provide safe equipment, train, supervise, check the work site for injury or for potential injury producing situations, OSHA requirements, comply with OSHA requirements, and obviously a person who's not an employer does not have OSHA duties. And so the complaint, and the reason I think the judge was correct in his conclusion in the judgment, is that Burke goes in at great lengths to establish with ultimate facts that there was a direct employment relationship with Steinberg. They do that, I think, where this intersects is they do that because they're trying to get, in the underlying case, liability established as to Steinberg personally, and they can't do that unless they establish that relationship and they plead that
So you
relationship.
live by the sword, you die by the sword. So let's say though that that's rejected, it's not, we just leave that aside, we don't agree with you, that's allegations of an employment relationship as it's contemplated in the exclusion. What about my alternative point I was making about the fact that even if Steinberg, is not an employer of Rodriguez, that Rodriguez was an employee of an insured, any insured or an employer contractor of any insured.
I agree with that, and I think that was the second.
But Alamo and what was the-
Alamo, first of all, it's a trial court opinion in a federal court.
Right.
But it's a different, it interprets a different exclusion. It is the standard exclusion, not the exclusion in this case. In this particular case, in our case, the court has to look at the exclusion in our policy. In fact, the standard exclusion was deleted by the endorsement, and the endorsement in our
How
case.
different and what?
So it's much broader. The standard exclusion, I'll have to read it.
Is it section 112E, is that the one?
It's in Alamo. Do you mean mine or Alamo's?
Well, are you saying that the employer exclusion was excluded here,
The employer exclusion in
the standard?
the Cypress policy is called contractors and employees of contractors. It is much broader than the standard exclusion of the policy, which was deleted by this endorsement and replaced by this endorsement. So this endorsement actually is different because it says, number one, bodily injury to any type of employee or worker, that's broader, of any insured, to any contractor hired or retained by or for any insured, that's not part of the standard endorsement, or to any employee of such contractor, meaning a contractor retained by or for any insured.
Cornucopia, if he was an employee
It-
worker.
Everything, it is
So everything.
much, much broader than the standard exclusion, which for,
So what interplay does the separate insured?
the interplay between those is that you have to apply the analysis independently to each one of them. You apply independently to botanical, you apply independently to Steinberg. That's the effect of how they interact. Here, all the parties conceded, and by the way, botanical didn't appeal and Steinberg didn't appeal. Burke, the plaintiff in the underlying case, is the one that appealed. Everybody conceded that based upon the allegations of the complaint, there's no coverage for botanical because botanical is alleged to be a direct employer. So it makes no logical, rational sense analytically to say that there's no coverage for botanical, and we concede that the exclusion applies because Horticopia was a contractor of botanical, and then say, but it doesn't apply as to Steinberg because the allegations are identical, which is what Judge Browning said in the opinion.
Well, what about
But
from here?
getting back to your
That's-
question
that's-
of.
No, we don't, I mean, yeah, okay, go ahead.
Yeah, so the standard exclusion, I'm just trying to find it, is much narrower and it doesn't have the buyer for or the three separate
Okay,
categories of
but
employees.
focus on the word any.
It does
I'm not sure
focus.
that distinction is pertinent.
I-
Unless you explain why it's pertinent.
Well, to me, I think grammatically, this exclusion is written differently and follows.
Did the premier case reject the argument that I've been?
The premier case is a little bit different because it was not an employer or contractor.
Did it reject the argument I'm expounding, which is because it says any, okay, after we find, the Worcester court held that a severability clause contained in the policy required that each insured be treated as having separate insurance coverage.
Right.
That portion, so, it essentially said, yeah, to enforce the severability clause would not give effect to any insured, but we'd rather just give effect to the severability clause and ignore the any insured. Why is that not?
I think the difference is that the premier case involved the intentional acts exclusion. It was a sexual molestation case.
Okay.
And so the question there was whether you impute the intentional act from one insured to the other. It didn't focus on the status of the injured party. It focused on the intent of the particular insured. So I think they're very different. I don't think it's.
Here, Rodriguez, the status of the injured party is Rodriguez.
Right.
Okay, I have to read it again to.
Yeah, I think, to me, that's the way that I see
Or
it.
we just reject it because it's not our district.
Well,
But Ellen is gonna tell us it's
Well-
super sound.
well, I do think that it stands for the proposition of you analyze the coverage for each insured separately without imputing one to the other. I think.
So so let me do it this way in a hypothetical then. So for Steinberg, let's assume he's an employee, that Rodriguez was an employee of Steinberg. If Steinberg is directing Rodriguez to go fix the roof that's not in his business, then does that fall under the exclusion? Because he's only an insured when he's within, I believe how it's described, when he's, let me see there, I don't just, with respect to conduct of your business.
So the honor exclusion, how it's framed, is that the injury has to arise out of and in the course of the employment or retention of Rodriguez. So
So then does it matter that he was injured cutting branches above 15 feet when the contract said that's as far as he's supposed to go?
the complaint, it doesn't matter. The complaint tries to, again, kind of have its cake and eat it too. I think those allegations are intended to say this was not part of the contractor, but it's one of two, and either way, the exclusion applies. Either Steinberg hired him directly, because I think that's the inference with the 15, and if Steinberg hired him directly, we only stop here, bodily injury to any type of employee or worker of the insured, Steinberg.
But an insured is defined under section 2, who is an insured, right?
Correct.
And a limited liability company, which we're dealing with, you are an insured, your members are also insured, but only with respect to the conduct of your business.
Correct, and Steinberg certainly was an insured with regard to the conduct of his business. The complaint alleges that he chose the lift, that he delivered the lift, that he brought the lift, that he
Okay, so
used.
to my question, if he had directed Rodriguez to go do something
Something else.
outside, then he,
Something
He wouldn't have-
completely different, I agree. If he had directed Rodriguez to pick up his kids at daycare, let's just make it completely different, that would not be part of the conduct of this business. Then Steinberg would not be covered at all, even without the exclusion. He just would not even be an insured at that point, if that makes, I think, does that answer your question? Yeah, so I do agree that here, because of this language that says, if this person is injured and he is an employee of a contractor hired by an insured or hired directly by any insured, either way, there's no coverage under this exclusion. And again,
So give me an example of coverage with these facts.
the policy, anytime the injured party is an employee or worker, and in the scope of his duties of that employment or work, there is no coverage. This is a general liability policy. The intent is to cover injuries to the public or damage to the public, not to workers. That's why there's a workers' comp exclusion. And by the way, the complaint alleges that he did receive workers' comp from Horticopia. Again, there's a little bit,
conflicting.
there's conflicting allegations in the complaint.
Although he could have been a co-employee.
So, but for example, are you asking me for a non-employee, or are you asking me for somebody who could conceivably be an employee? Let's say that the employee was, I can't even think of it, it would have to be completely unrelated to their employment. Let's say, for example, that they walked into the office and slipped and fell, and they came that day with their mom because their mom wanted to get landscaping services, and he wasn't working that day, but he slipped and fell. There would be coverage, because then the duties owed to him are duties that are owed to the general public, not based upon the employment relationship. So that's a little convoluted, but that's where you would get coverage. So it would have to be taken apart from any duties owed to him as a result of that employment or working relationship. So I wanted to address, unless you don't have any questions about this, this issue of whether Judge Brunning kind of went on a, let's call it a side quest, speaking about the underlying case, because I think it's immaterial. I don't think it matters that Judge Brunning put in the judgment a couple of paragraphs talking about the underlying case and the posture of that case. It was a discussion that was had at the trial. I think it was a sort of intellectual discussion. We'd just gotten back from COVID. There's a lot of intelligent people talking about intelligent things, and we did have a discussion regarding the underlying case and the law that may apply. I don't think that means that Judge Brunning departed from his role of what he intended and needed to decide. He was very clear that the issue that he considered in the judgment, it says whether there is a duty to defend Steinberg in the underlying action. He did not try to address any issues regarding Steinberg's potential liability or non-liability in the underlying action, whether it was discussed or not, sort of as an intellectual exercise. And then in the ruling, he did rule based upon the four corners of the complaint. He did like the argument better that there was a direct employment relationship that was in fact alleged, but also said any amendment would be irrelevant and would still not create coverage because of this issue that the policy excludes coverage for bodily injuries to a worker of any insured, whether that was Steinberg or whether that was Botanical. And I think based upon how this exclusion is structured, it specifically, it differentiates it from the standard exclusion, and it's broader and more encompassing to achieve this contractors and employees of contractors exclusion. I don't know if you're interested, and I can address, there was some notations in the brief that the appellant did not know where the judge had obtained some of the facts. For example, number one, the Botanical was a Florida limited liability corporation in the business of yard maintenance and landscaping. The complaint clearly alleges that, and obviously we have the two contracts that are attached. The complaint says that they were involved in landscaping. Steinberg is a sole manager and member of Botanical. That's in paragraph 7. I will concede, I don't know that the complaint uses the word sole. However, everybody assumed it to be true because it was true, but it does say he's a member or manager. I don't think it matters whether there was some potential other person out there that might have been a member or manager. I think it's irrelevant, so it's a little superfluous. Working as a hands-on employee, I thought that was an important point, and paragraphs 47, 50, 52, again, he is said to have chosen the lift, delivered the lift, provided the lift, had previously used the lift. Those are all hands-on actions. So while the complaint doesn't use the words hand-on, I think the inferences and the fair reading of the complaint is that he was a hands-on employee as well as a hands-on owner-operator. There was a question about whether Botanical was hired to remove debris and tree branches following the hurricane. The complaint actually says storm in paragraph 78, not hurricane. This incident was September 24, 2017, which we know was shortly after Hurricane Irma. And so again, distinction doesn't matter whether it was a storm or a hurricane. They were there to remove the debris and tree branches. That is alleged in the complaint. That he used Botanical utilized employees of Cornucopia, paragraph 44, that he was directed to work in a self-propelled platform, aerial life to cut tree branches, paragraph 43, while cutting branches, he was electrocuted, and that's paragraph 14. Every single fact that the judge puts in the judgment that appellant says were not supported by the complaint, they're all in there, either directly or a fair reading and inferences to be drawn from the words used in there. So I'll wrap up to say that either way, either the complaint alleges that Rodriguez was a direct employee of Steinberg based upon the duties alleged and the conduct alleged, and if so, the exclusion clearly applies. even assuming that he's not alleged to be a direct employee or worker of Steinberg, the exclusion still applies because the language is very broad and it is intended to encompass not just the direct employee, but the employees or workers of other contractors retained by or for any of the insurers. Now, we know that, again, it's alleged in the complaint that Steinberg is the one, and I'm actually going to point that out. Steinberg is alleged to be the one who retained him. So paragraph 40, on or about September 2, 2015, Steinberg, as member and manager, authorized Botanical Solutions, entered into a contract. 41, he, as a member and manager, an authorized agent, entered into a contract. 42, Steinberg personally was responsible to perform work at Katz's residence. 43, specifically then, that on September 24 and during the week immediately preceding September 24, on the request of Mark Steinberg. So we know that Steinberg personally is soliciting the work of Rodriguez by or for Botanical or himself. So based upon this broad language that is clearly intended, and an appellant has not pointed out any ambiguity, and while I agree that if there is an ambiguity, it has to be interpreted in favor of the insured, no ambiguity has been pointed out here. This is very...
Your time is up.
Thank you, appreciate it. I would request that the court affirm the judgment. Thank you.
Get your microphone set up again, and then you'll have 5 minutes, okay?
Thank you. So the first thing I'd like to address are just a few inaccuracies, and that Ms. Torres made, probably unintentionally, but she said that they made some argument about the exclusion being broader. They didn't make that argument at all in their brief. I don't think it's relevant here, but they didn't make that in their brief at all. And so we would argue that to the extent they're relying on that, they waived that. With respect to, again, and they also say covered only if not talking about the work that he did. And we respectfully, we disagree. I think we're gonna have to agree to disagree about whether or not she and I are going to have to agree to disagree whether or not there's anything in the judge's decision that goes beyond what was in the allegations of the complaint. We do assert that the recitation of facts that I previously cited to are facts that were not in the brief.
The policy language says arising out of employment or retention. So even if he was criminally treated as too tall, I mean, even if his work wasn't within the strict parameters of the contract, didn't the bodily injury arise out of during the course of his employment or retention by, if you accept the any insured theory that I posited, which was yes rejected by Premier?
Well, we disagree that would be rejected by Premier, but certainly the allegation of the complaint says that, right? So.
No, but you're saying, yeah, you're saying many things, but I mean, you're saying that Rodriguez was not, one of the things you're saying is Rodriguez was not acting in the course of his employment or retention by any contractor or in any insured.
Well, I think what we've established here is that the complaint says both, right? So both of those things are there.
I don't know, time to, but, the Premier, I mean, the accepted the Worcestershire Court, Massachusetts Supreme Court's reasoning, but that reasoning was based on an idea that to accept the theory that, you know, Cyprus is advancing would render the severability clause completely ineffectual, but is that even true? I mean, it could be effectual in other scenarios, just not in this one.
Wait. I didn't look at whether it was, in other scenarios, but certainly, but I'm sure it could, but it's also applicable here as well. So if the court doesn't have anything further, you know, we are requesting that the court reverse and remand to the trial court in order that the trial court find that it has a duty to defend and indemnify Cyprus.
Thank you.
Okay.
Interesting case. You both did a good job. Be careful going home.
Thank you.
Okay. Thank you, Your Honors.
Thank you.
We're adjourned to deliberate and conference these cases.
All rise. Thank you, travel safely.
Thank you.
Okay, thank you for your assistance.
Oh, you're welcome, ma'am.
Only do appellate stuff.
But I do